The videos on this channel are for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Watching of these videos or links contained within the site do not create an attorney-client relationship between the channel and the user or browser. Rule 1.0 Purpose and Function of the Rules of Professional Conduct. On May 10, 2018, the California Supreme Court issued an order approving new rules of professional conduct, which are effective on November 1, 2018. On September 26, 2018, the court issued an order approving non-substantive cleanup revisions to the rules. These revisions are effective on the same date. A. Purpose. The following rules are intended to regulate professional conduct of lawyers through discipline. They have been adopted by the Board of Trustees of the State Bar of California and approved by the Supreme Court of California pursuant to Business and Professions Code Sections 6076 and 6077 to protect the public, the courts, and the legal profession, protect the integrity of the legal system, and promote the administration of justice and confidence in the legal profession. These rules, together with any standards adopted by the Board of Trustees pursuant to these rules, shall be binding upon all lawyers. Business and Professions Code Sections 6076 and 6077. 6076. With the approval of the Supreme Court, the Board of Trustees may formulate and enforce rules of professional conduct for all members of the State Bar. 6077. The rules of professional conduct adopted by the Board, when approved by the Supreme Court, are binding upon all members of the State Bar. For a willful breach of any of these rules, the Board has power to discipline members of the State Bar by reproval, an act or expression of criticism and censure, the expression of formal disapproval, public or private, or to recommend to the Supreme Court the suspension from practice for a period not exceeding 3 years of members of the State Bar. B. Function. 1. A willful violation of any of these rules is a basis for discipline. 2. The prohibition of certain conduct in these rules is not exclusive. Lawyers are also bound by applicable law including the State Bar Act, Business and Profession Code, 6000 ETSEQ, and opinions of California courts. 3. A violation of a rule does not itself give rise to a cause of action for damages caused by failure to comply with the rule. Nothing in these rules or the comments to the rules is intended to enlarge or to restrict the law regarding the liability of lawyers to others. Business and Professions Code, 6000 ET-Sec. And what follows? This chapter of the Business and Professions Code constitutes the chapter on attorneys. It may be cited as the State Bar Act. C. Purpose of comments. The comments are not a basis for imposing discipline but are intended only to provide guidance for interpreting and practicing in compliance with the rules. D. These rules may be cited and referred to as the California Rules of Professional Conduct. Comment 1. The rules of professional conduct are intended to establish the standards for lawyers for purposes of discipline. See Ames v. State Bar, 1973. Therefore, failure to comply with an obligation or prohibition imposed by a rule is a basis for invoking the disciplinary process. Because the rules are not designed to be a basis for civil liability, a violation of a rule does not itself give rise to a cause of action for enforcement of a rule or for damages caused by failure to comply with the rule. Stanley v. Richmond, 1995. Nevertheless, a lawyer's violation of a rule may be evidence of breach of a lawyer's fiduciary or other substantive legal duty in a non-disciplinary context. See also Mirabito v. Liccardo, 1992. A violation of a rule may have other non-disciplinary consequences. See example Fletcher v. Davis, 2004, Enforcement of Attorney's Lien, Chambers v. K, 2002, Enforcement of Fee-Sharing Agreement. Comment 2. While the rules are intended to regulate professional conduct of lawyers, A violation of a rule can occur when a lawyer is not practicing law or acting in a professional capacity. Willful violation of a rule does not require that the lawyer intend to violate the rule. Phillips v. State Bar, 1989, and see Business and Profession Code, 6077. Comment 4. In addition to the authorities identified in paragraph B. 2, opinions of ethics committees in California, although not binding, should be consulted for guidance on proper professional conduct. Ethics opinions and rules and standards promulgated by other jurisdictions and bar associations may also be considered. Comment 5. The disciplinary standards created by these rules are not intended to address all aspects of a lawyer's professional obligations. A lawyer, as a member of the legal profession, is a representative and advisor of clients, an officer of the legal system and a public citizen having special responsibilities for the quality of justice. A lawyer should be aware of deficiencies in the administration of justice and of the fact that the poor, and sometimes persons who are not poor, cannot afford adequate legal assistance. Therefore, all lawyers are encouraged to devote professional time and resources and use civic influence to ensure equal access to the system of justice for those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. In meeting this responsibility of the profession, every lawyer should aspire to render at least 50 hours of pro bono publico legal services per year. The lawyer should aim to provide a substantial majority of such hours to indigent individuals or to nonprofit organizations with the primary purpose of providing services to the poor or on behalf of the poor or disadvantaged. Lawyers may also provide financial support to organizations providing free legal services. See Business and Profession Code, 6073. Business and Profession Code, 6073. It has been the tradition of those learned in the law and licensed to practice law in this state to provide voluntary pro bono legal services to those who cannot afford the help of a lawyer. Every lawyer authorized and privileged to practice law in California is expected to make a contribution. In some circumstances, it may not be feasible for a lawyer to directly provide pro bono services. In those circumstances, a lawyer may instead fulfill his or her individual pro bono ethical commitment, in part, by providing financial support to organizations providing free legal services to persons of limited means. In deciding to provide that financial support, the lawyer should, at minimum, approximate the value of the hours of pro bono legal service that he or she would otherwise have provided. In some circumstances, pro bono contributions may be measured collectively, as by a firm's aggregate pro bono activities or financial contributions. Lawyers also make invaluable contributions through their other voluntary public service activities that increase access to justice or improve the law and the legal system. In view of their expertise in areas that critically affect the lives and well-being of members of the public, lawyers are uniquely situated to provide invaluable assistance in order to benefit those who might otherwise be unable to assert or protect their interests, and to support those legal organizations that advance these goals. This has been Rule 1.0 Purpose and Function of the Rules of Professional Conduct. Thank you for watching. Like, subscribe, click the bell, comment.